Can you believe this? I'm still in shock. But a California appeals court just struck down a law that requires the use of transgender pronouns. I mean, the last state on earth that I expected to do this was California, but it appears that the First Amendment actually still does apply in this country, at least sometimes. Let's talk about this. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit like, hit subscribe, turn on your notifications. Don't miss any of these videos. You don't want to miss anything. All right, here we go. Here's the article. We'll take a peek and then we'll talk about what actually happened in this case, because it's kind of fascinating to see a court uphold the First Amendment, not only in California, just in general, but especially on an issue like this, an issue that has such astroturfing going behind it. Here we go. The court, this is from Blaze Media, but you can actually find this article written in a lot more slanted ways on a lot of other publications, and man, they're kind of pissed. So I picked Blaze because Blaze Media, believe it or not, was the neutral article. Court rules California law requiring use of transgender pronouns is a violation of free speech. The state of California 3rd District Court of Appeals ruled that a state law requiring the use of preferred pronouns by nursing home workers violated their free speech rights. Okay, so here's the situation. A little while back, I think 2017, California passed a law that required nursing home workers, very oddly specific, required them to not intentionally misgender transgendered nursing home occupants. Does that make sense? Okay, so you have a transgendered occupant in a nursing home. The nursing home staff is basically not required to use their preferred pronouns, but they are required to avoid using their non-preferred pronouns. Okay, so this is how legislatures try to get around things like the First Amendment. They say, well, we're not forcing them to do something. We're just saying that they can't do this other thing. The court even says in this, which we'll kind of talk about in a little bit, but the court even says, yeah, First Amendment treats those things the same, you dummies. You can't just do that. You can't just try and weasel your way around a right. A right is a right. Even though, of course, they weasel the ways around rights all the time. The court struck down the pro-transgender regulation on Friday in a unanimous 3-0 decision. Now, I'm going to take a little bit of umbrage with Blaze's reporting here. It's not a pro-transgender regulation. It is an anti-speech regulation. That's what it is. This has nothing to do with pro-transgenderism, and that's one of the main reasons that they ended up losing on this case. That this law didn't do anything to actually safeguard the transgender residents against harassment. In fact, the prohibition on the speech was not related to an actual harassing or hostile environment. And therefore, there was no actual service of the government interest involved that was sufficient to overcome the speech restrictions that were in place. We'll talk about all that in a little bit. The provision was part of the LGBTQ Long-Term Care Facility Residents Bill of Rights, passed in 2017 and signed into law by then Governor Jerry Brown. The bill's author, State Senator Scott Wiener from San Francisco, released a statement lambasting the decision. The court's decision is disconnected from the reality facing transgender people, said Wiener. Wrong, buddy. Your law is disconnected from the reality that the First Amendment exists and recognizes a right to speak, and strongly guards against government compulsion of speech or government prohibitions of speech. That's the problem that you've got. Deliberately misgendering transgender person isn't just a matter of opinion, and it's not simply disrespectful, discourteous, or insulting. Rather, it's straight up harassment. It actually is not. That is an incorrect legal statement. That is not how harassment works. And in fact, the court addresses this in their decision, where they say that It is disrespectful, discourteous, or insulting. However, this law does not take into consideration whether or not this is done in a harassing manner, or even if the resident is aware of it. It can't be straight up harassment if the person isn't aware that they're being harassed. And that's part of the law. That's part of why speech provisions are so stinking difficult to enact. And thank God that they are. Because if the government can just compel you to speak in whatever way the government wants, then there is no more freedom of thought or expression. And it erases an individual's fundamental humanity. That's not actually true. It just is rude to them. Particularly one as vulnerable as a trans senior in a nursing home, Weiner concluded, this misguided decision cannot be allowed to stand. And let me reiterate, in case people are unclear on this, I don't think you should intentionally misgender people over and over again for the purposes of harming them. I don't think you should do that. That's not a thing that should be done, especially not in a nursing home and especially not by professional staff. However, just fire them. That's the answer. You just fire the person who does it. They don't need the penalty for this was up to $1,000 fine and up to 1 year in prison. Oh, here we go. The law could have punished a health care provider with 1 year in prison and as much as $1,000 fine for prolonged, which is nebulous, abuse involving the violation of the provisions, including the misuse of preferred pronouns. Sponsors of the bill defended the bill by saying such a punishment would be rarely enforced in only the most extreme cases. Remember how income tax was a temporary tax that was only on the top income earners and would go away once the war was over? That was what, 1919. That was a long time ago, 1906, I think. Of course, this is how it always starts. But one of the most important things to remember is that at the end of the day, every law that's passed is enforced with a bullet. Given a long enough timeline, it's some petty law that gets someone killed in an interaction with police. Because that's how it goes. That's how these things end up working. We've seen it from speeding tickets, selling loose cigarettes. We've seen it from handing out mixtapes. We've seen it all over the place. In fact, most of the people who sponsored this bill would be opposed to those police interactions over petty crimes in typical scenarios. In fact, San Francisco has said that they will, I think it was San Francisco, maybe it was LA. I don't know, one of them had said that they will not actually go after anyone who shoplifts less than $950. But up to $950, you just take it, apparently, and leave. Because they recognize that the enforcement of these petty crimes ends up with an interaction that could end with a bullet. And it's no different on a criminal restriction on speech as well. It's the same thing. Equality California, who sponsored the legislation, also released a statement through a spokesperson decrying unanimous ruling by the court. It was unanimous, by the way. 3-0 on the panel all said, yeah, you can't do this. Cannot do this. Let's be clear, refusing to use someone's correct name and pronouns isn't an issue of free speech. It absolutely is an issue of free speech. 1000% is it an issue of free speech. It's a hateful act that denies someone their dignity and truth. Wrong. It can be a hateful act that denies someone their dignity and truth. However, even if it is a hateful act that denies someone their dignity and truth, that does not mean that it's not an issue of free speech. In fact, many free speech issues are hateful acts that deny someone their dignity and truth. That's the whole free part of free speech. And it's a shame to see that so many people in this country have forgotten what freedom actually means. Freedom means risk. It means a lack of security. It means a propensity for harm. It means the possibility that your sensibilities will be offended from time to time. But we gladly exchange that for liberty. California's nursing home patients deserve better than this, and we'll be fighting until this decision is overturned, he added. So that's the story from The Blaze. But briefly, let's get into a discussion. The legal reasons why this happened. It's pretty simple. There's one. There's one, and that is that a restriction on the content basis of speech has to be measured under something called strict scrutiny. So if your restriction on speech is content based rather than content neutral, content neutral restriction says doesn't matter what's being said. We don't care about the message underlying it. It's just that this would be like a time, place, and manner restriction. We don't want anyone speaking at this point in time. So, for example, a noise ordinance could be a prohibition on speech. Because, like, well, what? Speech after midnight is not allowed? Loud speech and expression? Well, no. But it doesn't matter what kind of speech it is or what the message is. If it's after midnight, look, man, people are trying to sleep. That's a time, place, and manner restriction that could be a restriction on speech or expression, but it's content neutral. So it is a lower level of scrutiny. Once it's based on content, and it's pretty hard to argue, although they tried, but it's pretty hard to argue that saying, look, when someone misgenders someone, that is when this speech provision kicked in. Well, of course, that's based on the content because it's based on them misgendering someone. If they don't misgender someone, there's no prohibition. So it's not content neutral. It is explicitly based on using a gendered pronoun that is contrary to what the person prefers. So therefore, content based. It's based on the content of the speech. Therefore, we go to strict scrutiny. Strict scrutiny says it must be, one, a compelling government interest. And the state argued successfully that there was a compelling government interest in the prevention of sex-based discrimination. And by extension, sex-based discrimination in California extends to discrimination based on the transgender status of a person. Okay, so the government apparently has a compelling interest in that. I'm not entirely sure I agree that that's compelling. It might be a rational government interest. It might be an important one. I don't know if it's compelling, but the court agrees. Court says, yes, this is compelling in the state of California. Okay, so now we move on to step 2. Is this restriction narrowly tailored to achieve the compelling government interest? Therefore, are there other less restrictive means that could be taken that would achieve the same goal? And does this sweep up other protected activities in its aim to accomplish the goal? The court says this is where they lose, that this prohibition sweeps up otherwise protected activity and it encompasses it, and it does not always serve to achieve its ends. It's not narrowly tailored. I mentioned this during the reading of the article, but the ultimate basis comes down to this. The government is arguing that these sex-based discriminations, the use of the intentional repeated misuse of pronouns by a worker in this facility amounts to harassment, and that their compelling government interest is reducing or removing that sex-based harassment, right? That's what we just talked about. However, this law does not require actual findings of harassment in any way. In fact, this law does not require an actual finding that the person being misgendered is aware of the misgendering. So, for example, how this plays out. Let's say you have 2 workers and they're in the back room talking about a patient. Worker A notices that worker B always refers to a patient as her, even though she is a female to male transgendered person whose preferred pronouns are he and him. So never to the person will they reference them as her. They'll just either avoid using the pronouns or maybe they'll even use the preferred pronouns. But in the break room, around the water cooler, discussing with coworkers, they always intentionally use the thing. They use the wrong pronoun at that point for whatever reason. This suddenly becomes harassment, according to how they argued this case. But the law does not require a finding of that harassment. And of course, if they went to court, it'd say, no, I never misgendered this person to their face. I couldn't have possibly harassed them. And then the court would say, yeah, but that's not what the law says. The law doesn't require us to find harassment, just that you had a repeated misuse of pronouns. Therefore, you lose. Game over. That's it. The person loses. This is sweeping up otherwise protected activity. Let's say a person was posting on Facebook and intentionally misusing pronouns to make a point or whatever. They would be subject to this law as well, so long as it was within the provisions. Like if they're referencing a particular client or something like that, and someone else recognizes, oh, you're actually talking about someone of a different gender, suddenly it becomes a crime. But this is still America. We still have free speech, and the court in this case recognized it, and that is important. So good job on the appeals court in California upholding this. I'm sure they're going to take it to the Supreme Court, and we'll see what happens there, but that's going to be a long ways out. For now, freedom wins the day. And let me just remind you that though the speech may be unpalatable or even despicable, there is no merit in protecting only happy, friendly, wonderful speech that everyone agrees with. There is only freedom when we protect the speech that people disagree with, and most importantly, the speech that you personally disagree with must similarly be protected. But let me know what you think down in the comments below, where we're on YouTube, so who knows if they'll protect your speech or not, but I won't delete any of them, and I'll try and give them a read and see what you got. Y'all have a good day. Till next time. Peace. Peace.